With the music of London Rain in the background, Hush and Whispers, you're on the legal line with Dennis Kennelly and my very special guest, Dick Block, tax lawyer par excellence. And we're also joined today, well, we're not joined by him because we wouldn't be on the air without him, our engineer, Aaron Delatorre. And neither one of my normal producers are here, so Aaron is doubling up as producer. We've got Laura Espinoza London, who works with me at London Rain and in my law office, is busy doing some legal work for me today. And Nikki London is going to sound engineering school, which is great. She's going to knows a lot about it already, but is actually getting a degree in it. So we miss him. But Aaron and I are soldiering on along with Dick. And we've been talking about independent contractors and some horror stories. One of the most confusing things, both from a tax law standpoint and from a legal standpoint generally, is that there is not one test as to whether someone is an independent contractor or not. And what I mean by that is you've got the federal labor standard, the state labor standard, the IRS standard, the franchise tax board standard, the workers' compensation standard, and if you've got a pension plan, whatever is defined in a pension plan as an employee. So to say it's confusing would be an understatement. I think cutting to the chase at the end, and we'll show you how we get there throughout the rest of the show, it is always far, far cheaper in the long run, even though it is somewhat of a pain in the neck. But once you get your system set up, it's not that hard, is to classify people as employees. I mean, that's the simplest thing. There are no surprises. And quite frankly, that is what I advise most of my management clients. Dick and I will be happy to give you some hints as to what you can do if you really want to use independent contractors. But the situations under which you can use them are very, very limited in my view. Dick, would you agree?
I do agree, Dennis. And as a matter of fact, the good advice you're giving me reminds me of the advice of the judge in the song Making Whoopee, in which he says to the young man getting a divorce or looking for a divorce decree, I think I'd keep her. It would be cheaper.
Amen. Yes, there's an old joke a buddy of mine came out with, and he said I asked him, he'd been through 3 very acrimonious divorces. And I said to him, are you ever considering remarrying? He said, no, I have a new solution. I said, what is it? He said, I'm going to find a woman that hates me and buy her a house. And to this day, he has not bought any more homes. So I think he's...
Good way to keep track. Okay.
Yeah, the other old joke is my ex-wife is a good housekeeper. She marries you and keeps the house. But or it could be said either way in this economy where the woman can be the primary wage earner. So, okay, and this may be more accounting than anybody else, but it's not that hard actually to treat somebody as an employee. Just generally, what do you have to do with them as far as paperwork's concerned?
The employer files quarterly with the Internal Revenue Service a Form 941 and annually a 940, which is the unemployment insurance at the end of the year, prepares and sends to the Social Security Administration, to the employee, and to the IRS a Form W-2 for the employer to report his income on his 1040 tax return. The equivalent forms for the state of California are a DE3, a DE88, and of course the W-2 reflects the state and local income. That's basically the filing requirement on an employee. The accounting portion of it, of course, is maintaining the proper records, seeing that the trust fund withholdings are properly segregated and set aside. The interesting thing, at least to me as a lawyer, is the determination of whether a person is an employee or an independent contractor. There is a basic test of employment, which is the right, not necessarily exercised, of the employer to control not only the result to be reached by the worker, but the means and method by which he accomplishes that. And that is where the fun begins. The federal government used to have a 20-point test checklist, but now it uses what they call a behavioral analysis.
Sounds like you need a psychiatrist.
Yes, and the prescription is still a difficult one. The state has other tests, and then to make it more complicated, the federal tax law at least has two categories of statutory employees. That is, regardless of what is done, they have to be withheld on, and statutory non-employees, and that is those people, those workers who, regardless of what happens, are treated as independent contractors. And with it being that complicated, where there are good faith errors made, there are a couple of provisions that the IRS employs to get things sorted out. For example, if you have misclassified a series or a group of people as independent contractors, even though they're clearly employees, but it's an honest mistake, and you've done it for a long period of time, and you've treated everyone in that category consistently as independent contractors, the IRS will simply ask you to convert over and not chase you for the back taxes.
Which is saving you a bundle of money.
Yes, but you have to be in good faith doing it. This is what is called the Voluntary Classification Settlement Program, and you have to agree to classify those workers as employees for all future periods, and of course, there is a form to file. It's called an 8952, and you enter into a closing agreement, which is essentially a contract with the Internal Revenue Service.
Does the Franchise Tax Board have a similar provision or not?
I have not come across one. The Franchise Tax Board in these matters, as generally, is much more aggressive than the Internal Revenue Service. Although, Dennis, with my, unfortunately, many years of practice, I have come across some situations which turn out to be a little bit humorous. As I mentioned earlier, the IRS and the Franchise Tax Board can seize the employer's property to pay the unpaid employment taxes.
So they can grab your car, they can grab your house, they can grab your bank account.
And they can grab your business. Many years ago, I had a client who was operating an Italian restaurant pizza parlor. And I can't mention its name because it's still in business and is a very popular series of locations. But what happened was that because of some personal issues, the owner, an individual, failed to pay employment taxes, notwithstanding my efforts and the efforts of various accountants and Internal Revenue Service and Employment Development Department personnel. And finally, the IRS and EDD issued a notice that they were going to come seize the business. So the owner closed the store, walked out. This was in the middle of the summer, left everything in cheeses and rising dough where it was, and just locked the door and left. 2 or 3 days later, I arrived with the IRS and EDD people, and we opened the door, and the place was covered with mold growing on the cheese and the uncooked dough. And the IRS guy and the EDD guy looked at each other, said, "Do you want this? No. Do you want this? No." And they walked away.
So there it sat.
I'm sorry?
There it sat.
Well, the brother of the owner came in, took over the place, and operated it through a new corporation. And as I say, it is still in business and doing very, very well.
So did they ever chase the former owner, the guy that had abandoned it for the back money?
He was and remains uncollectible.
For those of you who don't know what uncollectible means, that's effectively the IRS or the Franchise Tax Board saying, you don't have enough money for us to bother with you.
That is correct. But there is a moral to that story. As I said, it was the gentleman's brother who took over, and the moral of that is that for tax purposes, a person is not his brother's keeper.
And it worked out very well for the person that was not acting as his brother's keeper, since apparently he's got a thriving business. Yeah, the personal liability is what kills you. And, you know, just another example of where you can get into trouble is when you've got somebody doing work for you and they're injured on the job and you think they're an independent contractor, so you haven't bothered to get a workers' compensation insurance. And what happens there is, and, you know, this can run into thousands of dollars. If somebody gets injured on the job who should have been treated as an employee and hence covered by your workers' comp policy, if you have one, is that guess who pays the money? Guess who pays the medical bills? Dollar for dollar, 100%. The employer. And if the employer is good old YOU, you know, you could be facing $50,000 to $100,000 in medical bills if somebody falls off a ladder or something like that in your business. So Mark Sullivan and I, who's a colleague of mine with whom I work a lot, recommend that you check your homeowner's policy to make sure that, for example, for people that are coming in to do work on your roof or your gardener or somebody like that, make sure there's a workers' compensation rider that will take care of a lot of this for you. Your gardener, if he's an independent guy and does 25 other people or 50 other people, is likely going to be viewed as an independent contractor, especially if he's got his own business. But if you got a gardener working for you full time and you're the only person for whom he's gardening, you're going to have a problem. Now, do you still, Dick, another interesting question is what do you do with household employees? Let's take the nannies. Somebody comes in and watches your children, and you're the only person they're working for, and you set their hours. They seem to meet most of the traditional tests for employment.
Hello?
Yeah, I'm here.
I'm sorry.
Well, I was talking about the nannies. You've got a nanny that works for you, watching your children. You're the only household for which she labors, so that your kids are the only ones she's watching. She probably works 5 or 6 days a week for you. You set her hours. You say when she can go to lunch. You say when and if she can take a break. And by most standards, she's going to be an employee. Is that how you see many people treating them in your practice?
Well, I would imagine that would be the appropriate treatment, except for the law. There are 3 categories of individuals who are treated as statutory non-employees. Remember, I mentioned that.
Yes.
1 is direct sellers. 2 is licensed real estate agents, as compared to someone who does not have a license. And 3, companion sitters. I would imagine the nanny falls into that category, as does the caregiver for an elderly person. And so, notwithstanding the logic of reason, those persons are not considered employees.
For federal tax purposes.
For federal tax purposes, and the same rules apply for the Employment Development Department.
How long has that exception been around?
As long as I am aware, I can't say it goes back to the time I started to practice law, but it probably goes back a very long way, because it is, I would say, less convenient for the employee and more so for the employer.
Absolutely. And besides, most people in Congress have nannies.
Very good.
So it works out very well for them.
Both Republicans and Democrats.
Absolutely. It's a bipartisan situation. So we're going to take a break in about 10 seconds. Mind you, you're listening to KHTS 1220 on your AM dial. You're on the legal line with Dennis Kennelly and my guest, Dick Block, and we will be back after these words. You are back on the legal line with Dennis Kennelly on KHTS Radio, AM 1220 on your dial. With me, my good friend, tax law maven, Dick Block, and we're talking about that wonderful subject of independent contractors and the do's and don'ts of it. One of the things that has popped up recently is the use of leased employees. A leased employee is the employee works for somebody going all the way back in history to a company called Manpower. They used to do it, where the employee works for Manpower and the company contracts with Manpower to provide them with, of all things, manpower. And but the taxes are withheld, benefits, if any, are paid by manpower. And that sounds like a pretty good out to me as far as getting out of all this paperwork. Of course, it's a little expensive. What do you think, Dick?
Well, it can make life a lot easier for the employer, but in many respects, the employer is still very much restricted. For example, the leased employee, unless he or she has an equivalent retirement plan from the lessor, is required to be counted for purposes of the employer's retirement plan.
So, as an example, I am Dr. X, a world-renowned plastic surgeon, and I make $1 million a year in my practice. So what I want to do, obviously, is pay as little tax on that as possible. And one of the ways I do that is set up a very rich retirement plan. And I don't like employees, so what I do is I have my Nurse Jones, I lease her from the XYZ Medical Personnel Company. And I pay her, well, XYZ pays her X, and I pay XYZ so much per hour for her service. Now, I go to the IRS and want to get my really, really rich retirement plan approved, which includes only me. Is it going to be approved or not?
Not today. In the past, there was a way that I accomplished getting it done.
Well, that's because you're a genius.
The definition of employee at one time was the same for purposes of withholding tax and retirement plan inclusion. And at that point in time, I was able to obtain a ruling from the IRS for a particular leasing company that the Nurse Jones, as you describe her, was the leasing company's employee. Today, that would not work because the definitions have been modified to prevent what the IRS viewed as an abuse.
Absolutely. Well, we want to let people know how to get in touch with you. So if anybody wants to go to you for tax advice or for estate planning advice, how do they get in touch with you, Dick?
The easiest thing is to give me a telephone call. My office number is area code 818-716-1585. And if you would like to get a little more information about my background, I do have a website, which is richardblocklaw.com.
And Block is spelled B-L-O-C-K, correct?
That is correct.
And I neglected to mention that Dick is Harvard educated, where they really learn it, and as I believe has a master's in tax law, which not many people have. And I am proud to call him my tax lawyer. Just to let you folks know where you can get in touch with me, my phone number is 310-746-9106. The email is kennelly.dennis@gmail.com. And if you give me a call, I'll give you a free half hour over the phone to let you, we'll figure out if you have the need of my services or have a problem or have an issue, and we can certainly do that within the hour. So get a pencil, write this down. My number is 310-746-9106. My email is kennelly.dennis@gmail.com. And I've got a website, which is, of all things, DennisKennelly.com. Dick, why don't you give your number again so the folks can write it down?
818-716-1585. 1585. Email taxmaven, TAXMAVIN, at sbcglobal.net. And the website is Richard Block with a CK law .com.
That is great, and I want to thank Dick for appearing on the show. As usual, he was splendid and spectacular. And just to let our listening audience know, the On the Legal Line is going to take a summer hiatus. We're not going to be on this summer. It's hard to find guests during the summer. But we will be back in the future. And I want to thank everybody here at KHTS. They have been marvelous hosts. I want to thank station manager Carl Goldman and his lovely wife, Jerry. I want to thank my engineer, Aaron Delatorre. And Aaron, what was the name of who's the chief engineer, sat in for a couple of weeks? Justin, I think.
Justin Powell.
Justin Powell, who I stumped on sports trivia. Want to thank my producers, Nikki London and Laura Espinoza London. And most of all, I want to thank you, our listening audience, because we do this for you. We've had a lot of fun doing it, and we look forward to talking to you again. So you've been on the Legal Line with Dennis Kennelly, and see you in the fall.